Hello everyone, my name is Mustafa. I'm an associate professor at Ufa University of Science and Technology and also legal counsel. Welcome to my channel, Mustafa Contract Law Hub, where I'm planning to tell you about everything you need to know regarding contract law. Whether you are a student or a professional or just someone interested in understanding contracts better, you've come to the right place. So, let's embark on this journey together and explore the fascinating world of contract law. Today, I'm going to talk about this important concept. As you see, the role of consideration to form new contract. In fact, I told you about the consideration, but today it's this time and this video is about the differences between common law and civil law. You know about the consideration. Consideration in general means something in return you pay to an offerer. In fact, if I'm an offerer and I give you some offers and or promises in return, you pay me something, you give me something, maybe some acts, maybe prices of that promise that I made. So this is consideration. But about the valid contract and enforceability of a contract, we need to think about this requirement or this concept that we can call them as requirement under the common law, and on the other hand we see the contract for formation and also to be enforceable is in another way and is another formalities that I try to tell you today about these details, something that we see under common law that we don't see under civil law and vice versa. Under common law, consideration in common law, I told you about the requirements. These requirements that I told you for formation of a new contract, an agreement, intention, capacity, certainty, and consideration. So this consideration is the requirement under common law. In fact, if we need new contract, valid one and enforceable one, so we must have consideration. So this consideration can be an act or maybe price or payments, or you may only provide or give your promise in return and so on. So it's must. You have to do it because this consideration under common law is requirement. And also key principles under common law. When we want to know about the consideration and the details, we need to see and look at these key principles. The first one, as you see here, the consideration under common law must be sufficient and not to be adequate. What does it mean? It means we need some kind of value about this consideration. We don't need to exact price or exact or equal price of that consideration, of that promise in return. In fact, if you see offer gives you the offer and in return you have to do something under common law, so it must be sufficient, just some kind of value, not exact price or fair in monetary terms. It's important as the first key principle, and the other is some kind of exchange. So we are, for example, two parties to this new contract or new agreement, and if I promise you to do something or based on my offer, in return you have to do something. You pay me some special amount of money, or just you give me your words to do something or don't do something, and so on. And also past considerations now valid under common law because it's not sufficient as well. In fact, the time of formation of contract is so important, and the negotiations. Through the negotiations, you must do something, and also legal detriment and benefit. The party to the contract may be incurring, not maybe, definitely incurring legal detriment, and on the other hand, the other party may be or definitely benefit here. So you see, we have these situations. If there is detriment, on the other hand, we have legal benefit as well under this new agreement and contract. Significance under the common law, as I told you, is requirement. When we see this is requirement, it means for formation of a new contract under common law, we need to have consideration. And no matter what type of consideration you have, is based on the consent, but we need to have it, it's a must. And also for a contract to be enforceable. So these two elements are so important for valid contract and also enforceability of a new contract. And also I must add here, if we don't have such consideration, it means we don't have enforceable contract unless we see some other maybe manners and mechanisms to make the contract enforceable, like put this new agreement in formal documents like deed. And by this deed, you see the enforceable contract or agreement. And here, examples like paying money for goods or services, or performing an act in exchange for a promise that is made by an offerer, and foregoing a legal right. But how about the civil law? Consideration under civil law. When we speak about the civil law, so it's easy because I told you about the nature of this consideration under contract, under common law, and we need the consideration as a requirement to form a new contract and enforceable one. So this is the common law. On the other hand, we don't have such a concept exactly in same technical sense as common law, because under the civil law we have formalities, we have mutual consent that is enough for formation of new contract, and in addition, that parts that I told you about the requirements, capacity, certainty, enagreement, intention, offer, acceptance, I told you about all of them. Here, this consideration is not important for enforceability or formation a valid contract under civil law. Key principles, as I told you in general, first of all, focus on consent and formalities. The formalities are so important, and mutual consent. And no need to think about the consideration as a requirement unless we have it in special jurisdictions, or maybe we have it based on some special codes or decree of laws and so on. And also objective and formal elements. It means we need only formal elements for formation a valid contract. As I told you about the intention, valid intention, and also capacity, certainty, offer, acceptance, and these elements are the elements that we need them to form a new contract. And also no need for consideration is the thing that I emphasized by my words, and only we need to the elements, and consideration as a requirement is under the common law. significance. So, enforceability and making or creating a new contract, valid one, under civil law, don't need to have consideration, because the main things are formalities and also the mutual consent. And if we have, if I ask something, if we have some formalities based on jurisdictions or depending on some specific codes, so maybe under them we need to have some considerations, but otherwise in general we don't need to them. Here you see this table in summary. If we think about the consideration, these aspects, 4 aspects, I listed here on the common law and civil law. We can analyze them. Consideration on the common law required, but on the civil law we don't need to consideration. And nature of consideration must be sufficient, some kind of value we need on the common law, but not exactly fair in monetary terms. And on the civil law, exactly not relevant. In fact, the mutual consents are important between the parties, and the past act or acts here under common law generally not valid, but under civil law not applicable, because again mutual consents are important, and enforcement for enforceability of a new contract under common law we need to consideration. And also if we want a valid contract by these requirements I told you. But under civil law, just we must see the mutual consents and also that capacity, certainty, valid intentions, and offer acceptance, and maybe some formalities we see depending on special codes and jurisdictions. The last words, if I want to tell you, if under common law, we need consideration for a new valid contract, for formation of a new valid contract, and also enforceability of a contract. But under civil law, we don't need to consideration as a requirement, but maybe by some formalities we see this requirement, we see this consideration as a requirement for some types of the contracts. But in general, we don't need to consideration under civil law as same concepts as I told you under the common law. Thank you so much for joining me today, and I wish you the best as always. See you soon. Bye.